Right. Settle down, everyone. Settle down and pay absolute attention. Today's lecture is not some casual overview, okay? This is a strict, definitive masterclass designed for one singular purpose, structuring the perfect 16-mark answer on bailment for your KSLU examinations. Every single point we discuss today, every statutory section, and every legal outline is precisely what the evaluator expects to see on your answer script, nothing more and absolutely nothing less. Let's begin.
Here is your required synopsis. 1. Introduction and Bail Act. 2. Essential elements of bailment. 3. 5 kinds of bailment. 4. Duties, Bailor and Bailee. 5. Rights of both parties. And 6. Landmark case laws analysis. Now, I am explicitly instructing you to frame this exact agenda as your index of answer on the very first page of your exam booklet. You must write these exact 6 headings before you begin your main text. Strict KSLU evaluators look for this index immediately, and if it's missing, well, you've already lost their favor.
So, we start with our first heading, 1. Introduction and Bail Act. When you write this on your answer script, underline it clearly to demarcate the start of your legal explanation. Presentation is just as crucial as knowledge.
Read what we have here. Bailment is a common legal relationship in commercial transactions under the Indian Contract Act 1872, involving the transfer of possession of goods for a specific purpose without transferring ownership. Now, listen carefully. You must deliberately dissect that distinction between possession and ownership in your answer. You are transferring the custody, the physical control of the good, purely for a commercial transaction. You are not transferring the title. Think about it. If I give my watch to a mechanic for repair, he has possession, but I absolutely retain ownership. This distinction is the bedrock of your answer. Moving on to Section 148 of the Indian Contract Act 1872, a bailment is the delivery of goods by one person, in brackets bailor, to another, in brackets bailee, for some purpose, upon a contract that the goods shall, when the purpose is accomplished, be returned or disposed of in accordance with the directions of the bailor. In your exam, you are going to write this Bail Act provision exactly as it is, directly in the center of your page. Highlight that section number. Furthermore, clearly define the parties underneath. The bailor is the person who delivers the goods, and the bailee is the person who receives them.
Moving to our second synopsis heading, 2. Essential elements of bailment. I remind the class once again that writing a massive, unstructured paragraph will fetch you mediocre marks at best. Breaking definitions into clear, structural elements is how you secure maximum marks.
Observe the strict life cycle of this contract. Step 1. Delivery of goods. Step 2. Purpose of delivery. Step 3. Return or disposal after purpose. Step 4. Ownership not transferred. These bullet points enforce the chronological progression of a bailment contract for the evaluator. First, the goods must actually move from one person to another. Second, there has to be an explicit, legally valid purpose. Third, the absolute duty to return or dispose of the goods once that purpose is met. And finally, the caveat we just discussed, no title transfer. Write them exactly as steps on your paper.
We now transition to the third heading, 3. 5 kinds of bailment. I am warning you right now, missing any of these 5 kinds in a long-form answer will result in an immediate deduction of marks. Evaluators check for all 5.
Let us compare the 2 primary categories. Gratuitous bailment, made without consideration and can be terminated at will, subject to conditions. Now compare that to non-gratuitous bailment, made for reward or consideration, where both parties derive benefit. Now consideration is the legal quid pro quo, something in return. If I lend my friend a book for free, it's gratuitous. If I rent a car for a daily fee, it is non-gratuitous. I strongly advise you to draw this exact comparative table format on your answer sheets. It shows the evaluator immediate conceptual clarity.
You must also include the remaining 3 kinds. Bailment for safe custody, goods delivered for protection or storage. Bailment for hire, goods delivered for use against payment. And finally, bailment by finder of lost goods. Finder has rights of a bailee and can sue for reward if announced. I want you to elaborate strictly on this last point in your exams. You see, the finder of lost goods doesn't have a formal contract with the owner initially, right? But the law imposes a quasi-contract. The finder holds the unique legal status of a bailee, meaning they inherit all the strict duties of care until the true owner is found.
Introduce your fourth heading. 4. Duties, Bailor and Bailee. I must emphasize the heavy marks weightage placed on citing the correct statutory section numbers here. Without the section numbers, your legal arguments are completely hollow.
Memorize these duties of the bailor. Duty to disclose known defects, Section 150. Duty to bear extraordinary expenses, Section 158, specifically in gratuitous bailment. Duty to indemnify bailee, Sections 159 through 164, for losses due to the bailor's fault. And duty to receive back goods. They must accept goods after the purpose is fulfilled. Let me explain the strict liability regarding defects. Under Section 150, if the bailor gives goods for hire, they are responsible for defects whether they knew of them or not. And regarding indemnification, if the bailee suffers any loss whatsoever because the bailor's title was defective, the bailor has to make good that loss. Make sure these sections are prominent on your page.
Now, shift your focus to the duties of the bailee. Duty of reasonable care, Section 151, care of a prudent man. Duty not to make unauthorized use, Section 154. Duty not to mix goods, Sections 155 through 157. Duty to return goods, Section 160. And duty to return accretion, Section 163. Let us pause here and deeply dissect Section 151. What exactly does the KSLU evaluator expect when you discuss the care of a prudent man? It means the bailee is bound to take as much care of the goods bailed to him as a man of ordinary prudence would, under similar circumstances, take of his own goods of the same bulk, quality, and value. Write that exact phrasing down.
Move to the fifth heading, 5. Rights of both parties. A crucial tip for your legal studies, rights flow directly from duties. Where one party has a duty, the other automatically possesses a corresponding right.
Examine this balance of legal power. For the rights of the bailor, 1. Right to delivery of goods. 2. Right to terminate bailment. 3. Right to sue for loss. 4. Right to accretions. And for the rights of the bailee, 1. Right to deliver as directed. 2. Right to necessary expenses. 3. Right of lien. 4. Right to sue third parties. 5. Right to deliver to any joint bailor. Displaying this balance side by side on your script demonstrates superior comprehension. Now pay special attention to the bailee's right of lien. A lien is a fundamental right. It means if the bailee has rendered a service involving the exercise of labor or skill regarding the goods, they have a right to retain those goods until they receive their due remuneration. Explain this thoroughly to secure those top marks.
Look up, everyone. Command absolute attention here. We have arrived at the final, most critical heading, 6, Landmark Case Laws Analysis. I am informing the class right now that this is the mandatory section that elevates an average answer to a top-tier KSLU 16-mark score. Without case laws, you will barely scrape a passing grade.
Case law. Coggs v. Bernard. This laid down fundamental principles of bailment and duties of bailee. Listen to my exact instructions for the exam. Write this case law in a separate boxed format and underline the case name to immediately capture the evaluator's attention. Let me detail the case facts. In this historic English case, the defendant, Bernard, undertook to safely move several casks of brandy owned by the plaintiff, Coggs, from one cellar to another. Bernard wasn't being paid. It was entirely gratuitous. However, due to his negligence, a cask was staved and the brandy was lost. The final ratio decidendi, the verdict of the court, was that Bernard was liable. Why is this absolutely relevant to your exam? It proves that even in the gratuitous bailment, once a bailee assumes the task, the duty of reasonable care attaches automatically. Your second mandatory citation is Union of India v. West Punjab Factories Limited. It recognized the bailee's responsibility and liability in handling goods. Again, write this case law in a separate box format and clearly underline the case name. In this landmark Indian case, the background facts involve goods being lost in transit due to a devastating fire on the railway premises. The Union of India, representing the railways, was the bailee. The final verdict held the railways completely liable. The absolute supreme relevance here is that it cements bailee liability by placing the burden of proof strictly on the bailee. The railways couldn't just throw up their hands and say a fire happened. No, they had to prove they exercised the rigorous care of a prudent man under Section 151 to prevent that fire, which they utterly failed to do. Explain the shifting of the burden of proof explicitly.
And so we reach our conclusion. Bailment ensures the safe transfer of goods, balancing responsibilities. This wraps up the substantive law. But I leave you with a final question to provoke some deeper thought on strict versus absolute liability. Exactly the kind of question an examiner might throw at you in a viva voce. But what happens to the liability if the bailee exercises prudent man care, yet the goods are still destroyed by an unforeseeable act, an act of God, perhaps? Well, if the bailee can strictly prove they took every single precaution Section 151 demands, the liability vanishes. It is an intricate, delicate balance. Master this structure, memorize these exact headings, sections, and case laws, and you will totally dominate this exam question. Class dismissed. Keep studying.